As you well aware that I am Dr. Jetling Velosa, running a YouTube channel called Law Speeches in English, Nyaya Prasang in Hindi and Nyaya Prasangalu in Telugu languages. It is a multi-language channel in which I am regularly posting my lectures on various gamuts of law as well as the world affairs. Today we discuss the role of constitution in shaping the modern India. So this theme I selected because we are celebrating the 76th Constitution Day, and which was fallen on yesterday, that is on 26th of November 2025. As you well aware that we got enacted the Constitution by the Constitutional Assembly from 1946 to 1950 by sparing around 2 years, 11 months and 18 days of time, and it came out with a magnanimous document by bringing all the best principles which are there in the other constitutions in the world at that time, and the Constitutional Assembly has adopted the Constitution on the 26th of November 1949, and which came into force on the 26th of January 1950. So, the Constitution, since its long travel of around more than 76 years, has resulted tremendous impact on all the sectors of the world, all the sectors in India, whether it is economic, agriculture, social, political, industrial, whatever sectors it may be there, the Constitution has a tremendous impact in its development. And our Constitution lays stresses upon the welfare state, because every act of the state is for the purpose of welfare of its citizens. And our Constitution became a big source for the many constitutions from Southeast Asia and African countries, because they got liberated in 1950s and 1960s. As on today, because India is running because of the due to the effectiveness of the Constitution. The Constitution, as you well aware, that declares India as a sovereign, socialist, secular, democratic republic. Very first part, that is a preamble itself, it has been stated. Then question came before the Supreme Court whether the Parliament under the Article 368 can amend the preamble or not, in a case called Berubari Union case. At that time, the Apex Court in 1950s had held that preamble was not a part and it cannot be amended. But later the same Supreme Court in 1970s, in a famous judgment called Keshavendra Bharati case versus State of Kerala, has reaffirmed that preamble can be amended and it's a part of the Constitution which can be amended, but without damaging the basic structure of the Constitution. So Parliament has that power to make any sort of amendments to any part of the Constitution, but only condition is that it should not damage the basic structure. In 1976, by 42nd Amendment, then government of Indira Gandhi had carried out, inserted the word secular and socialist in the preamble because she was impressed by the rapid progress which was heralded in Eastern Europe and also in the former USSR. And to provide a uniformity of religions, she added the word secular. In addition to that, unity and integrity was also been added by the 42nd Amendment of 1976. So the Constitution empowers that political equality. Everybody is equal and everybody has a right to vote and right to contest depending upon the nature of elections are concerned. In a famous case called Indira Gandhi versus Raj Narayan, 1975, supplementary SCC Volume 1, the Supreme Court had reinforced that constitutional commitment to have the fair and free election. That is a fundamental right to every citizen of India. And it was struck down. Certain draconian amendments were made in 1976 by the 42nd Amendment to the Constitution. And again, this same Supreme Court, in a case called Kihoto Holohan versus Jaco Hulu, 1992, supplementary volume 2, SEC 651, page number, upheld that the 10th schedule of the Constitution, where we have enacted the Anti-Defection Act in 1986, and this enactment of the 10th schedule is a good for democracy because we had curtailed the horse trading and defection from the one party to other party. So that has been enforced by the Supreme Court, and also it has given wide powers that stating that Speaker also comes under the judicial review. He cannot be a superman in the running the house is concerned or managing the house is concerned. Then, as well aware that we have the part 3rd of the Constitution provides fundamental rights which are very, very important and which are basic human rights to every citizen. Without that, we cannot survive in the society. And to articulating the part 3rd fundamental rights, again in the Keshavanda Bharati versus State of Kerala, 1973, volume 4, SEC, page number 225, the Supreme Court has came out with an innovative or novel idea called the basic structure doctrine. The Parliament has the power to amend any part of the Constitution but without touching the basic structure, and if the basic structure is got damaged, it may result into collapse of the nation and democratic format which we have erected all these years. In one more important case, that is the Maneka Gandhi versus State of Union of India, 1978, SEC, page number 248, the Supreme Court has again reaffirmed that the Article 21, life and personal liberties, which are guaranteed as a fundamental right in that article, where the Everybody has a right of going abroad. That is also a fundamental right, and that cannot be curtailed by any other manner. Subsequently, in a case called the Justice K.S. Puttuswamy versus Union of India case is reported in 2019, Volume 1 SEC, in which case the apex court had stated that right to privacy also a fundamental right, a human right that cannot be violated. The state has no right of violating that human right under any circumstances, as we are party to the Universal Declaration of the Human Rights document of 1948. That also be called as the Aadhaar case. So these interpretations of the Supreme Court, one way or the other, is taking our nation into the correct path. Then the Supreme Court, again in one more case, also defined what is meant by federalism and what is meant by secularism. That is a very popular case called the S.R. Bommai versus Union of India, 1994, Volume 3 SEC. In this case, Supreme Court has clearly stated that the Constitution under the Schedule 7 clearly demarcates the division of the power between the union list, state list, and also concurrent list, and the statutory powers are enlisted there. Then the federalism is another important aspect that we have to uphold for every government which be coming to there in the governance. That was affirmed by in this case. With this case shows the path of development of the strengthening of the development of the federalism in India is concerned. Then in one more case called the Unni Krishnan versus State of Karnataka and T.M. Pai cases, the Supreme Court has stated that right to education also a fundamental right. It cannot be denied. It is the responsibility of the state to provide free and fair, free and compulsory education to the primary level. So that is the reason we enacted the Compulsory Education Act of 2009, which providing that the primary and elementary education should be made as a not only compulsory, and state has to encourage that education. But the thing is that so far India is not covered the higher education in this sphere, and even courts also not covered the higher education in this sphere. Why? Because there is a lack of resources are there, and the Supreme Court's time and again also reaffirmed the labor protections, then social justice policies of the government is concerned. And you know that our society is not a completely equal society. For that we have the Article 14, 15, 16 articles are there which provides the right to equality. And when we speak about the right to equality, equality should be among the equals, not between the unequals and the equals. To bring them into the mainstream into society of the unequals, they should have we adapted the reservation policies. And in remarkable case like the Indira Sahani versus Union of India 1992 supplementary volume 3 SEC page number 217, the Supreme Court has upheld that providing of the reservations to the other backward classes, basing upon the BP Mandal recommendations, which the committee was constituted by the erstwhile Morarji Desai government in 1979. So the central government level the educational institutions and also employment opportunities should be some 27% of the chunk of that should be reserved for the other backward classes. And in the same case, Supreme Court also stated that the government can classify the backward classes into the backward and more backward. But the same Supreme Court in Champakem Dorarajan case of 1950 struck down the classification of the backward classes into backward and more backward. But in this Indra Sahani case, it has put out that backward classes can be classified as per the backward and more backward. So with that view only, a new policy was introduced that will be called as a creamy layer policy. Only creamies will be excluded from the purview of the reservation and the non-creamies only given the reservations. So that is that has been inserted in the constitution. So that is also, this case also leading to a kind of social transformation of India is concerned. Then in one more case called the Vinith Narayan versus Union of India 1998, volume 1 SEC page number 226, the Supreme Court has strongly came out with the practices of corruption in India is concerned. The corruption should be curtailed because we have a number of enactments are there, anti-corruption laws are there, but there are we have seen the rise of the corrupt practices everywhere. So the government has, the Supreme Court has in this case also strongly advocated that we should curtail the corruption at the political level, executive level, administrative level, at all the levels. That was a opinion of the Supreme Court, and it is also, this decision also leading us to attainment of a transformative society is concerned. Then, so Supreme Court time and again has coming out with the number of innovative things like the data protection, because these days are no artificial intelligence and data protection and other things are there, the surveillance is there. That should not be there. If the state or the private parties indulges in the theft of the data, then they using the without the consent of the data, then they are liable for it, and it is a responsibility of the courts to provide the courts to governments to procure as a preserve such a kind of things should not be happened. Then, so for time and again, so the Supreme Court is shaping the future of modern India. We have got developed a lot if we compare the economic status of the during time of independence to that of today's. We are aspiring to become a world power, third largest economy in the world, and we have government have set out the Viksit Bharat vision documents from 1947. But in that way, the Supreme Court also leading, and Constitution also leading us to attain whatever objectives we are enshrined under the Part 4, that is the Directive Principles of State Policies. So I can conclude that without the Constitution we should not be like this, because the majority of the nations are, even after countries which have gained majority in our South Asia, or to say in Africa, where they have failed in one way or the other, their constitutions are not preserving the democracy. But in India, as on today also, we are preserving the democratic polity, then systematic rule and rule of law, judicial review. Why? Because this is the strength of the Constitution. Without this wonderful Constitution, we could not able to protect the India, and in years to come the constitution will definitely lead us to India becoming one of the major industrial power. So with this I am concluding my lecture. I request all of you to subscribe to my channel and share my lectures among your communities. Thank you one and all.